Okay, everyone, we're about to start. We're having a talk with Ben Powell about the copyright-safe harbor is no longer safe. Ben holds a Bachelor of Laws from the University of Tasmania, where he developed a particular interest in copyright law and its impact on technical community. Before this, he worked in the IT industry for longer than he cares to remember. So please welcome Ben. Thank you, Ben.
Thank you. Welcome to the talk, The Copyright Harbour is No Longer Safe. Hopefully by the end of this talk you'll have a bit of an idea about the case between the Australian Federation Against Copyright Theft and IINet, who's an Australian ISP. So I'll just give you a quick rundown of about the presentation. Firstly, that's my blog and Twitter address if you want to follow me. Hopefully there won't be too much jargon. If I do say something that you don't understand, feel free to ask a question. I'll try and clarify it for you. I think I've taken all the lawyery stuff out of it. It's designed for non-lawyers, so if anyone has a legal background and was expecting a deep analysis of the case, unfortunately you might be disappointed. However, we do need to discuss the law, so hopefully I won't bore you silly with it. I've broken it up into three parts. The first part we're going to discuss the bits of the Copyright Act that apply to this case. The second part we're actually going to discuss the case itself. And the third part we're going to actually look at some of the models that have been put in place or some of the models that have been suggested to limit ISP's liability for authorisation of copyright infringement by their users. I've put all the references on the last slide if you want to read some more. You can ask questions during the talk, but try and keep them very brief. We've got quite a bit to cover today. So if you can ask a question in 2 lines, feel free. If it takes a bit longer, then maybe leave it to the end. Okay, so first we're going to start in a very lawyery way with a disclaimer. All the views are my own. It's also not legal advice. So if you have a specific copyright question, you may wish to speak to a lawyer. So why are we here? Why is this an important case? Well, it's the first time that the concept of authorisation has been really looked at since a case called Morehouse in 1975. So it's been some time since we've had a really deep analysis of authorisation. And that goes to the liability of ISPs for the actions of their users. So the users infringing copyright on an ISP's network, well, what's the liability of the ISP for that? And out of this case, it's highly likely we're going to see either an industry agreement or legislation that will give us a model for limiting or preventing infringement. And that'll throw up questions about what's reasonable for ISPs to do, what's a reasonable model, what's fair, and that brings up issues again of procedural fairness and natural justice. And we'll deal with that a bit later in the talk. As I said, it's quite possible that there'll be legislation that comes out of this as well. So we need to look at that legislation, look at what's efficient and effective, and how changes to the Copyright Act can ensure that we still encourage innovation and competition. Obviously, poorly drafted laws can have a very detrimental effect on those things. So I'll just give you a quick rundown of the facts of the case. IINet's been accused of authorising copyright infringement by its users. Now, most of the infringement uses BitTorrent. Probably don't need to explain what BitTorrent is. AFAC used a piece of software to log IP addresses and other information from the torrent swarm, and they used that to send to IINet in the form of notices. And they demanded that IINet enforced its customer agreement to take action. Specifically, they wanted termination. But they also asked for IINet to hand on these notices to potential infringers. And they're saying that because IINet didn't do that, because they didn't do what they asked, IINet actually authorised that infringement, so the copyright infringement that their users were doing. Now, IINet responded to this by saying, well, the information in the notices is insufficient. As we all know, IP addresses are not necessarily the best way of identifying users on the internet. So they said, look, we don't have enough information really to act on them. They also argued that certain sections of the Telecommunications Act prevented them from using the information. I won't go into those arguments. They were rejected by both the federal court and the full bench. I'm just mentioning it there for completeness. And so IINet said, look, we don't have any obligation to act. So now we'll move on to the law. So the case dealt with 3 important legal issues. The first one, as I mentioned, is authorisation. And that can be found in section 101 of the Act if you desperately want to look it up. INET put forward a defence, section 112E, and they also argued that their liability was limited by the safe harbour provisions of the Copyright Act. So let's just talk about authorisation. Now essentially the section about authorisation is a codification of a case called Morehouse. Now what happened in Morehouse was that the University of New South Wales put photocopiers in their libraries. And as people are wont to do, they photocopied things in those libraries. And it was argued that because they put these photocopiers in the libraries, they'd authorised the copyright infringement by the users of the libraries that were making copies of books. And they actually found that this was authorisation. And if you've seen those notices above photocopiers saying, don't copy too much of books, that's pretty much out of this case. So the Act was codified in the Act, and there are three factors. Now these are non-exhaustive, so you don't have to prove all three, you don't have to prove one out of the, or two out of the three. These are just things that you need to keep in mind when you're looking at whether someone has authorised infringement. So firstly, the extent, if any, of the powers, a person's power to prevent. So you've got to have a power to prevent the infringement. The nature of the relationship between those that are infringing and the person accused of authorisation. And whether the person accused of authorisation took any other reasonable steps to prevent or avoid the copyright infringement that was happening. So we'll deal with that in a little more detail. Okay, so the power to prevent. Now it has to be an ongoing power. Now the leading case that described what this means is tape manufacturers. There's also a UK case called Amstrad and the Betamax case from the US. So basically the idea is that you've got the power to prevent if you just don't do it. If you don't provide internet access, that's going to stop people pretty effectively, you would imagine. And so in tape manufacturers, they were manufacturing blank tapes, and the argument was, well, you can not manufacture blank tapes. That'll stop people from making copies. But of course, once the blank tape goes into the consumer's hands, you don't know what they're going to do. You don't have any further power over them. And the same sort of thing in Amstrad. Amstrad was those dual tape decks. And yeah, they could have just produced single tape decks, I suppose. But they didn't really have any ongoing control once people had bought the tape deck. They could use it for infringing or non-infringing uses. And that's the second point there. It's got to be primarily used for infringement. I mean, you've probably heard of the Betamax case where they said, look, it's got all sorts of uses as well as infringement. It's not a primary use. And the other thing is the extent of control that the person who is allegedly authorising the infringement has. So in the Kazaa case, also known as Sharman Holdings, I mean, they wrote the client, they had pretty much control over the network. There was a whole heap of things that they could do. And because of that extent of control of the users of the network, they were said to have the power to prevent, amongst other things. So the relationship between the alleged infringer and the authoriser, the leading case on this is a case called Cooper. You might have heard of this one, the MP3s for free case. What happened in this case is Mr. Cooper was providing links to MP3s that were of dubious repute. And it was said that the ISP that provided access to this site was authorising the infringement. And what it turned on was that they had quite a close relationship. They had ads on the ISP site, go to this site for MP3s. There was a financial relationship between Mr. Cooper and the ISP. So that was really how it turned on. There was a very close relationship. And then the crux of the matter, reasonable steps. What are reasonable steps that an alleged authoriser has to take to prevent infringement? So what is reasonable? I mean, we know that warnings about infringement are insufficient. In fact, in the Kazaa case, the judges thought it was very cynical. The pop-up notice saying, please don't use this network for infringing copyright, that was deemed as insufficient. So what is reasonable? Is it passing on the notices? You've been accused of copyright infringement, please stop it. Is it terminating someone's account? Is that reasonable? Well, that's what this case is all about. Okay, so I'll move on to the defence. Yes?
Sorry, you may be covering this at some point, but with that Millhouse case of copying a library, my understanding is that there's also some doubt because the way that the book publishing companies had found out about this was sending their own employees into the library to photocopy stuff of the books that the publisher published. And therefore there was a question of authorised by the company to copy the books.
Yes. Well, and that's also examined in this case, because DetectNet, the files that were being infringed. Sorry, the question was in the Morehouse case, the publishers actually sent people in to make photocopies and then report back to the publishers. So in this case, the same sort of thing happened. Essentially, AFACT had investigators that had made things available, and it was whether really they had provided a license to infringe by making those available. In answer to your question, in this case, it was rejected. So. Unfortunately, I can't go into all of the mechanics of the case. It is quite fascinating, but we only have 40 minutes, unfortunately. So the defence that IONET put forward was a defence in Section 112E, which was put into the Copyright Act to provide certainty for ISPs. Now, that probably sounds like a whole bit of gobbledygook, but essentially what it is that merely because you provide internet access, you're not infringing, or you're not authorising infringement, I should say. But, I mean, that begs the question, what does merely mean? What does merely providing internet access? Which is discussed in the case, funnily enough. So there's a narrow interpretation and a broad interpretation of what merely providing internet access means. AFACT, of course, went for a much more narrow interpretation, unsurprisingly. And they said, look, providing a service on which infringing acts occur, it's not authorisation, but once you know about it, it is, because then you've got a power to prevent it. So this defence is not available to you if you know about it. If you've been told this person at this IP address is doing the wrong thing, you can no longer say you're merely providing access. IONET obviously thought that was wrong and wanted to have a more broad interpretation of saying, look, if it's just a function of providing internet access, copyright infringement that is, then the defence is available. So, if it's because people are downloading BitTorrent, we don't have any control over that. We're just providing the internet access. It's only when it goes above and beyond. So when you have a special relationship like Mr. Cooper did with his ISP, that's when you don't have this available to you. And they also argued, or IONET also argued, look, the safe harbour is available to us. And what the safe harbour does, it's actually a very long set of provisions, but in essence it limits ISP's liability if they have sufficiently assisted copyright holders. So that might include repeat infringer policies, termination policies, an email address to send notices to, copyright infringement at isp.com, that sort of thing. And what happens if you can access the safe harbour provisions, or if you're available to use, it limits your liability. It may even extinguish your liability entirely. So let's get to the case. This is the federal court case, so it's a court of first instance. Justice Cowdery. So the findings were users infringed copyright. They were infringing copyright on the internet. He also said that each torrent was one instance of infringement. That's important for liability because obviously if every chunk of the file is an instance of copyright infringement, your liability is going to go through the roof. So each torrent, one instance. And he said, look, IONET didn't authorise infringement. And they didn't authorise infringement because they didn't provide the means of infringement. So it wasn't like Morehouse where they provided the photocopiers. IONET didn't provide BitTorrent. They don't write the code for BitTorrent. They don't have a big flashing part of their website that says download BitTorrent here or anything like that. So they don't provide the means of infringement. He also said the notices didn't relate to a power to prevent the infringement. Termination is not a power to prevent. It's not an ongoing power. You basically, once you cut them off, that's it. People can go to another ISP. You're not going to necessarily stop copyright infringement. And he also said the notices weren't a reasonable step. And that really came down a lot to the volume of notices, literally wheelbarrow loads of notices. So it wasn't reasonable for IONET to act on them. He also talked about the evidential requirements in these notices. He agreed with the Section 112E narrow interpretation, so that defence wasn't available. So if they had been found to infringe, to authorise infringement, then that defence wouldn't have been available. And he said that the safe harbour provisions would apply. So even if they had been found that they had authorised infringement, they would be able to rely on the safe harbour provisions to limit their liability. So a big win for IONET, basically. That's out of order. We'll go back to that one. So, as you probably know, AFACT appealed. Now I'm just going to go through Justice Emmett's judgment, which is the primary judgment. There was a dissenting judgment and another one, but I'll just go through the primary one. He agreed with Cowdery about the number of instances and the fact that users were infringing copyright. However, the differences between the two cases, he did agree that there was no authorisation, but vastly, vastly different reasons. Firstly, he said that Justice Cowdery's assertion that IronNet didn't provide the means he rejected that argument. He said, can't use BitTorrent without the internet. He also rejected the arguments about the power to prevent. They said, yeah, you've got the power to prevent, you can terminate them. It doesn't matter if other people are using that account. It doesn't matter if other people can go to another ISP. Once you terminate them, then that's going to reduce infringement. And he partially rejected the reasonable steps that IronNet was meant to have taken. He said that if AFACT had provided notices that had cogent and unequivocal evidence, we don't quite know what that means, but if they had provided cogent and unequivocal evidence of a user infringing copyright, and if they had provided some form of indemnification for IronNet, so if IronNet mistakenly disconnected someone and then they decided to take action against them, if AFACT had provided some sort of indemnity, then it would make it reasonable. And if they had also reimbursed IronNet for administering and monitoring the disconnection scheme. So there are literally wheelbarrow loads of notices. Obviously that's going to create quite an administrative burden on ISPs. So he said, look, if you have a system of reimbursement, then that makes it reasonable. So essentially, on that point of authorisation, IronNet really dodged a bullet. If AFACT had done those things, an authorisation finding would have happened. And one of the other judges did find that it was authorisation.
What's a dissenting judgment?
Okay, so a dissenting judgment is you'll have, say, three justices, like in this case, and the majority found that IronNet didn't authorise infringement, sorry, and the dissenting judgment found otherwise. So it's the minority judgment. And Justice Jaggett found that there was authorisation. And Justice Emmett, this one here, it was very close to authorisation, so IronNet really dodged a bullet. He also said that 112E was not available. That's the merely providing internet access, took that narrow interpretation. And he also said that the safe harbour provisions wouldn't apply. So if AFACT had provided cogent and unequivocal evidence, indemnity and reimbursement, IronNet would have been in a whole world of trouble. He said that IronNet's policies were insufficient, and he made a big deal out of the fact that there was no easy email address for rights holders to notify IronNet that people were doing the wrong thing. So obviously the liability that IronNet would have, that they wouldn't be able to limit their liability. So they really dodged a bullet. Now we'll go back to the other slide. IronNet's response, because they realised they just dodged a bullet, was to provide a model for preventing copyright infringement so they could limit their liability for authorisation. What they proposed was an independent body to resolve disputes between ISPs and rights holders. They talked about graduated penalties. They actually made the analogy of speeding fines. You don't lose your licence unless you do something very bad, but you don't lose your licence if you just get caught for speeding a few k's over the limit. You get a fine, and they talked about that being a way of graduating penalties. They talked about privacy protection for consumers, not releasing consumers' information to the rights holders. There was a funding model, so it closely followed what Justice Emmett suggested. Okay. AFACT really didn't agree with that, so they appealed to the High Court. That was heard in early December last year. The findings will be possibly handed down early this year. Hopefully not tomorrow, because that might make this talk a bit redundant. I don't think it'll be tomorrow. So until the final judgment, we're all speculating. So if I'm wrong, I can just point to the fact that, yeah, it's just speculation. Okay, so the issues that were covered by the High Court, of course, being an appeal, are the same issues. There were arguments about control and the extent of the control. So Justice French said, do they have enough? Do they have control over what their users are doing on the internet? Is sending notices going to stop infringement? Is that a power to prevent? Is that actually going to prevent infringement? Justice Hayne asked about individual choices over the use of the service. He said, look, people can download BitTorrent and infringe or not. So does IronNet have a power over that? It seems like the justices are being particularly harsh on AFACT. That doesn't mean that they're going to lose. They're the appellant. They're always going to get a harder time. So IronNet said, look, it's not within the power of IronNet to deny IronNet users access to particular bits of copyright stuff, short of denying access to the internet as a whole. So saying, look, we don't have any power over them. What they do on the internet, we can't stop them. No, we are only providing internet services. I mean, obviously AFACT disagreed with that. They said, look, they've got control over the account termination. They can shape the bandwidth. Once they're notified that this person at this IP address is doing the wrong thing, they can do something about it. They also talked about the relationship of IronNet to its customers. There's a rather long quote by Patrick Flynn, who was the counsel for the Communications Alliance, a lobby group, who was a friend of the court. And basically what they're saying is, look, there's going to be so much copyright material on the internet. How can you mediate that relationship as an ISP? You don't know what your users are doing. The entire sum of human knowledge will be on the internet eventually, if Google have their way. And then they talked about reasonableness, and Justice Keifel said, look, what about the reliability of these notices? Is an IP address enough? Is it reasonable for IronNet or ISPs to act on evidence that might not be cogent and unequivocal? We'll see what they have to say soon. So there have been several models put forward as a response to the case. These are models that are put forward by industry, essentially, to limit their liability. So I'm going to talk about those three. There's the IronNet model that I mentioned earlier. There's one put forward by the Communications Alliance. And there's the AFACT model, which is basically what they're asking ISPs to do, what they're saying that they should be doing to avoid authorisation. So this is from the arguments to the court. There's no actual model. Pardon my graphic design foo of just cutting this out of IronNet's paper on the issue. But that's how it's meant to work. So we've got an independent body. The content owners provide the notices to the independent body with cogent and unequivocal evidence. Quite know what that means, but cogent and unequivocal evidence. The independent body then authorises, if it's cogent and unequivocal, they authorise the ISP to provide the information to the independent body. And then if there is sufficient evidence and they've got the information, they contact the consumer, the independent body contacts the consumer to notify them or take action, so some sort of penalty, I would imagine. As you can see, there's no release of information from the ISP to the content owners, and there's no contact with the ISP to the content owner, so the idea is that essentially it's all done with this independent body.
So just following their model as well, where the content owners have to pay the costs of doing all of this, it's also part of the IronNet model, wasn't it?
Yeah, there was a funding model as well.
Content owners are funding the independent body.
Content owners and ISPs. So it was meant to be funded by industry, essentially. So there is a funding model. That if you want to read more about it, they've got a whole paper on it.
It makes sense if the content owners are only paying the salaries of the independent body.
Well, that's right, yes. So no, it's an industry solution. Okay, of course there are a couple of issues that come up here that are unanswered. Firstly, what's the nature of the independent body? Is it an administrative body? Is it a judicial body? What status do their decisions have? Are they final decisions? So they say, right, you've done the wrong thing, we're going to charge you $100. Does that mean that the rights holder who doesn't think that $100 is really sufficient can then take further action? Is it a final judgment? What's the appeals process? Who can complain? Is it just individual rights holders? I write a blog. If someone was breaching my copyright by misusing the Creative Commons licensed stuff on there, can I send in a notice? Or do we rely on rights holder bodies like AFACT? Obviously that comes into the volume of complaints. If every man and his dog who's a content creator can send in complaints, you're going to get a lot of them. What's the appeals process? Do you have to appeal, once a decision is made, do you have to appeal to the federal court at great expense? What are the evidential requirements? What's cogent and unequivocal? What does that mean? What burden of proof, what standard of proof are we looking at? Are we looking at on the balance of probabilities? Are we looking at the criminal standard of proof, beyond reasonable doubt? Somehow I doubt it, but who knows? What are the penalties? I mean, IronNet suggested speeding penalties as an analogue, but we don't know what the penalties are. And who's going to bear the costs So if I want to defend myself, if I want to say, no, I didn't do it, is it going to cost me $10,000? Well, I might choose to cop the fine. What are the costs and who pays them? So the Communications Alliance also put forward a model. Again, an industry body or an independent body, either funded by the industry or constituted by government, so a judicial body. They talked about accreditation of rights holders. So you actually need to go through an accreditation process which includes the accreditation of the methods that you are using to generate your notices. A limitation on notices, no more than 100 a month. 12-month reset period, so means that you need to actually have got several of these notices within a 12-month period. It resets after 12 months. And so it was a system of notices. So that's basically the model that we've got. Within 14 days of the infringement, the rights holder needs to send the ISP a notice including those details. Within 14 days, the ISP notifies the rights holder that they can't match that IP address or find the user that they're referring to, or it sends an education notice to the account holder. There's a 21-day grace period to seek legal advice or to appeal to the independent or industry body. And then if you've got further infringements, you've got 3 more warning notices, each with that 21-day grace period. 1 more infringement, what's known as a discovery notice is sent out. So essentially, the ISP then provides the information to the rights holder, who can then litigate. So your information goes to the rights holder and the rights holder will sue you. So there are issues with this. Again, the makeup of the panel, or the body. If you're appealing to a body that's made up of ISPs and rights holders, essentially you're appealing to a group of people who've made the accusation in the first place. And even with ISPs on there, they're not necessarily on your side. They're obviously going to look at their own interests. What are the evidential requirements? There's no sort of need to be cogent and unequivocal in there. Essentially, the only sort of accreditation is the way that these notices are generated by the rights holder. So, I mean, you would imagine that ISPs may be a little more conservative and just basically take any accusation. What are the appeal rights? You can appeal to the independent body, but if you don't disagree with that, where do you go next? Is it an administrative decision, or do you have to go to the federal court, which is amazingly expensive? What's the onus of proof? Who needs to prove what? Do they need to prove that you're infringing, or do you need to prove that you weren't? And what's the cost? Again, how much is it going to cost for me to go to that independent body and say, no, I didn't do it? If there are high costs involved, obviously people are going to cop the fine. And now we go to what AFACT is asking people to do. Now, there's no actual model. Basically, AFACT has said that INET ought to have acted on their notices. They should have terminated accounts. They should have passed on notices. So they send in notice, ISP matches the IP address to the user, and then takes action against the user. So INET has a characterisation of it, and I know it's characterised by INET, who's their opponent in this case, but it's actually quite a accurate portrayal of what AFACT wants to do. So essentially, the problem is, as INET is pointing out, there's no evidential requirements, just on accusation. What right of appeal do you have? You know, ISP cuts you off, you say, please don't do that, ISP. You don't have any right of appeal. And the costs are borne by the ISPs. So any number of these notices, you're taking 1,000 notices a month, or 10,000 notices a month, or 100,000 notices a month, that's going to cost a lot of money. And if you have administrative processes that are going to cost a lot of money, ISPs will hand that on to consumers, so cost of internet will go up. So these are all sort of graduated response systems, so colloquially known as 3 strikes or 6 strikes or however many strikes you have in the system. And they all have the same problems. They have evidential problems. What is the standard of evidence that needs to go before they take action? Is an IP address sufficient? I think a lot of people might disagree with an IP address being sufficient to identify someone. There are issues about procedural fairness and natural justice. I pointed out, particularly in the Communications Alliance model, you're actually, the people who are accusing you of doing the wrong thing are the people who are judging your appeal. That's not fair. There's an information asymmetry. So we might be able to read these notices and make sense of them. Your average person probably would not be able to and would need to seek further advice, which is expensive. There's issues about the costs. How can you make it fair access to justice? Proportionality of penalties. Is termination a proportional penalty? You might be actually penalising people who are not doing the wrong thing. So essentially, you cut off someone's account. There might be 10 people using that account and only one of them is infringing. You're punishing 9 people. And it treats the problem as one between rights holders and ISPs rather than rights holders and their customers. So it's saying ISPs, by providing internet where people are doing the wrong thing, we need to do something about that. Do something about ISPs rather than do something about the customers that are doing the wrong thing. So obviously things need to change. Now, rights holders use things like artificial scarcity to bump up their prices. And so things like release windows for material. Warner Brothers has just increased the release window for their material up to, I think it's 5 weeks between the time they release it on DVD and the time they allow people to rent it out. So they're creating this sort of artificial scarcity. That's got to change, unfortunately. The different distribution models are already starting to challenge. Obviously, Apple is big enough to swing their weight around, so iTunes has become quite big. But there will be other ones that start to come up. Streaming content, that's how a lot of people want to access their material these days. And there have been quite large changes. If we can sort out the licensing issue, and part of the problem is that the Copyright Act sets it up in such a way that these licenses can be so expensive that it stops people being able to stream content. There's been a breakdown of geographic boundaries. Obviously, geographic boundaries don't mean much on the internet. Already the BBC has taken some action. You can subscribe to their iPlayer and get access to all of their archived material. So that's $9 a month or something. Independent artists. I mean, I know Justin Bieber is one of these people that has been discovered on the internet, and that's a terrible thing, but we've got to take the good with the bad. There have been some independent artists that have risen up through the internet, and particularly YouTube. If AFACT is successful in being able to essentially say, look, users accessing X service or Y service or whatever are doing the wrong thing, then a lot of these models are problematic. And the development of these models may slow down. So what can we do? We need to recast the problem. Firstly, and I've already discussed a bit of this, it's an industry problem about the availability of content and the legal channels. We need to look at how the market is working. And if legislation does come out of this, and it is very likely that it will, we need to look at it in terms of efficient and effective regulation. It's very easy to sort of say, oh, it's about free speech, it's about access to culture for people. But unfortunately, that doesn't really wash when it comes to copyright arguments with government. What they want to know is, how is the market being regulated? And it needs to be efficient and effective. That is, any changes to the law that you make, you want them to only target the things that you want to stop. You don't want to have this sort of collateral damage. And it's got to promote competition. So, I mean, I know, particularly in copyright, it's a monopoly environment, but you've got to promote the ability of people to have startups for new services, new ways of distributing, new ways of being able to interact with their customers. Obviously, we've got to have a bit of deterrence in education, and we've got to look at the penalties. Again, that comes down to reasonableness. We've got to always focus on innovation. So we've got to make sure that any changes to legislation have efficient and effective regulation at their core. That is, it doesn't stop innovation. So we need to recast that argument. We need to make sure that what we're talking about is regulating the market in an efficient way. And one would hope that the case will come down in IONET's favour. I suspect it will be much more like the federal court findings, which means that we need to start recasting this problem so we can encourage politicians that when they make legislation, that we have this at its core. Thank you. So, questions?
Hi. I'm a GPL holder, copyright holder over BusyBox. Last year, I found Telstra violating the copyright on the T-Box. It took me 10 months to help them resolve it. But anyway, I wonder hypothetically if they were actually distributing this firmware over their Telstra internet, so they're violating copyright. If under the AFAC model, could they actually be forced to disconnect themselves from the internet?
It's a slightly different issue because in that case they're the primary infringer, so you'd take a copyright action against them. They're not so much the authoriser. I suppose what you could do is people who are downloading that, you could say, oh, they're infringing copyright, and you could send notices via Telstra to their users. That's a possibility. But in that case, Telstra is the primary copyright infringer, so you take action directly against Telstra. So.
It seems to me that the copyright holders and more than just the sort of the individual people who might own, copyright with things like BusyBox, but actually just the big media companies are getting a lot of say here, and it seems, especially from the Federal Court of Appeals readings, that a lot of the judges are very sympathetic to that and not even seeing the general uses of it, or even what could go wrong if AFAC just gets to send out as many infringement notices as it wants. What sort of indication do we have as ordinary people that there is a level of fairness there? What trust do we have in the judges that they're actually hearing not just the commercial side, but all of the sides, as you say, listening to the innovators as well?
Well, in this particular case, there are quite a few friends of the court, so quite a few people who weren't actually litigants that provided evidence, and one of them was the Communications Alliance. So there was actually quite a bit of evidence adduced that put those sorts of arguments forward, and IONET also made those sorts of arguments. I mean, it's not really up to judges to make the law, it's up to them to interpret it. So I suppose it's really making sure that the politicians get that information when they're changing the law, because when it comes to litigation, the judges are just interpreting the law, so it's what's written that they're interpreting that. So, I mean, they do look at reasonableness, and Justice Emmett did mention the number of notices, and that's why he said, look, it wouldn't be reasonable for IONET to act on this number of notices without some sort of funding model behind it. So those sorts of issues were canvassed, but ultimately it's up to judges to interpret the law. It's up to Parliament to make it. So in this case, or in copyright in general, the government has really taken a step back and they've gone, well, we want industry to sort it out. And I think that's a fairly unfortunate view. I mean, thankfully the Law Reform Commission is getting some terms of reference to examine these issues, but it is unfortunate that governments are seeing it as a real industry issue and not seeing some of the consumer points of view.
Sorry, but I'm not actually sure that's an answer to my question of whether I trust the judges.
You're asking a lawyer to criticise judges?
Yeah, sure. The judges are interpreting the existing law, but as we've seen, Justice Emmett is saying, no, it's unreasonable to get this volume of things, and the other judges are just basically saying, no, actually, it's perfectly reasonable.
Well, one of the other judges.
And there was the quote of the. You mentioned it a couple of times, and now it's got it in my head, but the requirements for how authoritative and conclusive the information on that was required to be, and that was, again, in the opinion of some of the judges, that had been the information that was supplied was reasonable, and then it wasn't, and for others it wasn't, and so forth. That's my biggest problem in this whole system, is that there is still that level of interpretation, and that still that idea that reading other bits of the law, I mean, we look at it and say, no, it's totally unreasonable for an ISP to cut off the entire family because of what one person might be doing, but the justices don't seem to be seeing that same side.
Well, they did. Those issues were certainly taken up when they were discussing the reasonableness of actions. You may disagree with the interpretation, and you may think that the interpretation needs tightening up. Well, if you want the interpretation tightened up, you need to make law. So if you decide that the case is going to have all these perverse policy effects, you need to codify something. And that's what happened with Morehouse. That's why we've got that part of the Act, because they codified it in legislation. So we weren't relying just on precedent. Donna?
I just wanted to ask one quick question, if we've got time, about the proposed INET model. In relation to communication between the ISP and the customer and the independent body and the customer. So in the case of a complaint, once the customer was notified, presumably by the ISP, would there then be contact between the customer and the independent body?
The customer's not notified by the ISP at all.
Right, okay.
It all goes through the independent body.
Sure, no worries.
Basically, the independent body will then contact the customer. The ISP doesn't have a role in that. And that's kind of important from the ISP's point of view, because they don't want to be seen as the people who are disconnecting them.
Yep, no, I understand. And the other question I had was, has INET implemented any kinds of internal policy changes that reflect their proposed model?
I don't know, you'd need to ask INET about that, but
sure.
I would imagine they would probably be waiting for the case to be handed down.
All right, thanks.
Hi, you touched on the availability of content from industry, and it seems particularly bizarre to me that we're treating content that's, I can ship a DVD from overseas and get it whatever time it's released in the US, but we're treating the same content shipped over an Ethernet cable quite differently. Is there a reason why the government isn't introducing legislation to help that efficiency along and guide them along a path to actually opening up market opportunities?
Well, I'd say they should, yes. They don't seem to be moving that way because they seem to be seeing it as a real issue of industry. I think that legislation that does that will make the market more efficient and effective. So they don't seem to be moving that way, though, unfortunately.
Just earlier, when the question was raised of the copyright holders and the producers themselves seeding the content within the BitTorrent network and then harvesting the addresses of the individuals that are downloading this content. If something like that were to be performed in a legal sense by a legal body, there would be certain approvals and processes that they would have to go through in order to get the permission to collect that information. What is the legality of the content providers themselves seeding that information and making it available for download? I mean, if they're doing that to me, are they not providing or enabling the copyright infringement in the first place? What is the stance on that point?
Okay, there's a couple of issues there. The first one is access to the information. INET did put forward a couple of arguments from the Telecommunications Act saying that they couldn't act on that information because it had to do with their users' privacy. Those arguments were rejected both by the Federal Court and the full bench. So, yeah, they can. They can do that. As far as them actually seeding the information, that was the problem. They were actually seeding, the private investigator was seeding information. INET said, look, the fact that one of your people is putting this up here, they're giving an implied license. So they're actually licensing it for people to use, people to download off BitTorrent. That didn't get very far, unfortunately. So, yeah.
Is that an instance of industry winning out over the consumer? Or is that, to me, that seems a great big giant can of worms to go into from a legal point of view?
I might think so, but the judge in the federal court disagreed. So, unfortunately, no.
Thank you, Ben. That was awesome, and thanks for this slide about recasting the problem. Whenever we've got a problem like this, what do you suggest we actually do about it, especially given that the consumer voice is completely missing in this argument, debate, whatever thing? What can we do as an enlightened community to actually get on the, take part?
Vote with your wallet.
Yes, vote with your wallet. Lobby. Write to your local member. Encourage them to do the right thing. There will be, I believe that the Law Reform Commission will be getting some terms of reference to examine some of these issues. So you can always make a submission. I encourage anyone to do so. I suppose it's just making people aware. And unfortunately, in this particular case, we've got a new Attorney General, so there may be some changes here. But unfortunately, Robert McClelland wanted to take a step back and said, look, it's an industry issue. So I think it's a matter of making people aware that there is a consumer issue here. And I mean, there have been, it's been out in the press quite a bit as well, the fact that consumers are not having a say. So there is pressure being brought to bear, but as individuals, make submissions to the Law Reform Commission, lobby your local member, write to the AG. All of those things do make a difference.
I'm trying. What if the content owners actually break the law in finding out who's copying it? How's that one go down?
Break which law? If you're asking about them sort of accessing your information in the BitTorrent swarm, that was examined. The defences of the Telco Act didn't apply, so they weren't breaking the law. If they break into your house and open up your computer and find copyright material, well, I think there's some laws that would probably apply there. But it depends on what you're talking about, which law.
Yeah, basically, I believe the BitTorrents are encrypted, and also there's copyright. You can only use this protocol if you agree not to do things like track down owners.
Well, that would be an agreement between BitTorrent and its users, and it's not really law. You'd be looking at trying to enforce that, so you'd need the BitTorrent to try and enforce that. I don't think they'd get very far.
So separate to the recasting the problem, if AFAC does go after the individuals in Australia, given that they haven't actually successfully sued anybody yet in Australia, wouldn't that be a better solution, because that just doesn't work for them, it seems? Suing individuals?
Well, the Communications Alliance model, essentially, after the set of warnings, does provide the user's information to the rights holder who's complaining, who can then sue the individual.
But some ISPs currently, I believe, already hand over user details, and those individuals still aren't getting sued as far as I'm aware?
Well, yeah, I mean, I suppose that's up to the rights holder which policy they decide they want to use. Obviously, they see that it's more effective to go after the ISP as an authoriser of infringement rather than going after primary infringers. That may change, depending on the outcome of this case. Another question here?
Maybe you could clarify what I seem to be interpreting of what you're saying, is that the Justice's view was that by watching what people were torrenting, what they were receiving at a particular IP address, isn't illegal. Breaking into a house obviously would be considered to be illegal, and therefore whatever they got would be dubiously submitted to the court. But what you are receiving on your connection isn't necessarily private and something that's protected.
Well, the sections of the Telco Act that INET tried to rely on didn't apply. You, as an individual, may have other remedies, but as far as the argument that was put forward by INET, no, those sections of the Telco Act didn't apply.
What are the current Australian privacy laws around what an ISP is allowed to provide about its customers to a random third party, possibly copyright holder?
So you mean if someone has made an application to the ISP to, because I mean you'd need to have some sort of, they can't hand it out just willy-nilly. There are rules that apply to small business or businesses that hold personal information. However, if, for example, they point to a copyright infringement or some other thing, and they say, well, on the basis of this person doing the wrong thing, we want you to release that information. You can release it for law enforcement purposes, or if there's a court order or any number of things.
So do they have to wait for the court order, or can they hand it over before there's a court order or anything like that?
Yeah, this is the funny thing about copyright law. It does give you quite a bit of access to information. You can apply for an order, or I mean, if an ISP decides that they want to hand over your information, you can try to make a complaint under the Privacy Act. You can write to the Privacy Commissioner. You may get some remedy there, but I think
right, so
the
I don't know what the
protections are
privacy
quite
laws
low.
are like is what I'm asking. Like, is there anything the ISP is not allowed to hand over under some sort of privacy rules?
Well, they're not allowed to. They're not allowed just to hand over willy-nilly private information, so information that can identify an individual.
Okay.
However, you know, if you've got a court order or if there's a copyright complaint, you know, it's up to the ISP to decide, well, are they going to hand out this information or not?
Okay.
The individual then would need to take action, and it depends on what information and the reasons for it. So it's a bit difficult to answer that question.
I'm just wondering, is any of this going to be applicable to, in any way, to someone who's running Tor, either as a normal node or as a Tor relay, or is that sort of a, like, will the outcome of this potentially have any effect on that, or is it sort of a different ball game?
It's a slightly different ball game. Maybe you could be done for authorising infringement, but I think it'd be very difficult to make out those three factors. Particularly since you don't really know what's going through your system. So I think that you'd have a great deal of difficulty making that argument.
It's true for anyone who has a wireless access point.
Yes.
I read through the federal court decision, and in the course of it, you know, just looking at the reasoning that the judge was applying, he seemed to have a real clue about the technology, or at least he had certainly done his research. Can you just comment about if you can just respond, your own personal feeling about how that looked in the subsequent cases, like with the case that's currently going. Do you have a sense of just what the level of understanding of the technologies is among the judges and justices? Because as we all know, the devil is in the details, and technology consists of nothing but details.
I'm actually always surprised at just how much justices do actually understand the technology that sits behind it. So certainly in the full bench of the federal court, they had a pretty good understanding. I mean, they all have large numbers of researchers and associates and the like that are providing them with this information, but they're pretty smart cookies. They do have quite a good handle on the technology. Maybe not down to the sort of level that people at this conference do, but certainly enough to interpret the law. Yeah, I think it's pretty good in Australia.
In order to be absolutely sure that someone infringes, wouldn't you have to look at the content of the traffic that the person is downloading? Okay, well, yes. I don't know about the laws in this country, but if you accidentally at the same time happen to capture and look inside my voice over IP packets, in many countries intercepting telephone calls is a pretty big deal.
Yep, and those were the sections of the Telecommunications Act that were put forward as a defence, and they were rejected. So there are intercept laws in Australia, and they were the sorts of ones that were put forward by INET, and they were rejected. So yes, you can do that, unfortunately.
Hi, I'm curious about why you seem to be keen to get the Australian government to pass legislation to fix some of this, given that such legislation will almost certainly be written by the United States should the Australian government sign TPPA. So how much confidence do you really have that this won't simply be legislated exactly the way rights holders want?
Well, I mean, you can take a step back and go, well, they're always going to do the wrong thing, therefore I'm not going to do anything. Yeah, they might do the wrong thing. But if we all take that attitude, then they will inevitably do the wrong thing. So really, I mean, I hope that they would legislate and make it so we do have an efficient and effective market. And I think if you put those sorts of arguments forward and you argue that strongly, then you might get some traction. Unfortunately, the international situation is fairly skewed towards rights holders, but I mean, like I said, you can take a step back and go, well, it's all going to go wrong, or you can try and affect the change. So it's a catch-22, but you've got to do something.
Okay, I'm afraid we're out of time. Thank you, everyone, and thank you. It's a thank you gift from the LCA this year teams.
Thank you.
Thank you.